Hello and welcome to another of the Legal Aid Agency's webinars on helping us say yes, basically helping us get things right first time so that we can make a good initial decision on your applications. My name is Peter Reid. I'm one of the technical leads on the merit side of legal aid, and I'm being joined by my colleague Stephen Spittlehouse, who is also technical lead. We'll be taking you through the webinar today. The first part of the webinar covers the information that we require in support of the initial application. And whilst some of this may appear to be very basic in terms of the information that we are requesting, it is in light of the fact that of those applications that we refuse on the basis that insufficient information has been supplied, once that information is subsequently provided on appeal, we grant over 72% of those refused applications. So whilst it may seem basic, what I'm about to cover, it is really the essentials that we need, and when they're not provided, it delays the application from your perspective and it creates extra work for both you and us. So starting off with, if you're acting for the applicant or the claimant in proceedings, we need you to upload any pre-action correspondence that you have had with the other side so that we can be assured that you have made all reasonable attempts to reach a settlement without having to resort to proceedings. Obviously, there may be some cases where the matter is so urgent that entering into correspondence is impractical and you've had to apply on an urgent basis for an emergency certificate to issue proceedings or to obtain interim relief or something of that nature. If that is the case, explain that in your merits report when submitting the application. If you're acting for the defendant, please upload copies of the claim form and supporting particulars of claim, all relevant supporting documentation, correspondence with the other side, copy of a tenancy agreement, copies of notice to quit if it's a possession case, and if there have been any court orders made at the point at which you're making the application, supply copies of those as well. It doesn't happen very often, but if you are seeking cover solely for counsel's opinion on the merits of the case, the statement of case must still set out the basis of your proposed challenge or your client's defence to the proceedings brought against them. It's not sufficient for our purposes simply to submit the application saying we want to obtain counsel's opinion, and without setting out on what basis you as a solicitor consider that the client has a claim or has a defence. Moving on to judicial review cases, we need to see a copy of the decision that is being challenged, or in the case of something where the local authority haven't made a decision, we need to see what they have been asked to do and why their refusal to do so is unlawful. We need to see a copy of the letter before action, but again, there may be circumstances where it is impractical to enter into protocol correspondence. If that is the case, spell that out in the application. And having sent the letter before action, we need to see that the other side has been given a reasonable time period within which to respond, all dependent on the circumstances of the case. And if they have sent a response, we need to see a copy of that as well. So again, we can see that you've taken all reasonable steps and exhausted all alternative remedies before resorting to applying for a certificate. Picking up on the circumstances where a case may be urgent, in most non-family matters, you do have delegated functions to grant an emergency certificate. We'll come on to the circumstances where you don't in a second or two. But if using delegated functions and if submitting a single stage application where you're applying for both emergency and substantive certificates at the same time, please remember to add appropriate scope limitations to both the emergency and the substantive application. We frequently see cases where the emergency limitations are simply carried forward onto the substantive application, which means that we then have to decide what scope limitation we are going to impose. And we may impose something that is more restrictive than you would like. It may be that the limitation is not what you wanted to see on the certificate, and that then just puts you to extra work in submitting a further amendment request. Having said that, there may be circumstances where we do consider that the scope limitation you have selected is too wide for the work that we consider it's appropriate to do, and we may therefore impose a more restrictive limitation. But if we do that, we will clearly indicate that that's what we've done in our decision, and we will set out the reasons for that restriction, and against that you will have a right of review or appeal. If you are delegating for a higher costs limitation than the current default limit of £2,250, please include your reasons for selecting that increased limit in the statement section of the CCMS merits report. We need you to spell out and to provide us with the justification for that increased limit before we can then ratify it when issuing a certificate. I said there are certain situations where you don't have delegated functions to grant emergency funding. That is largely in judicial review cases where there are restrictions on the availability of your delegated functions. But if doing so, if applying for an emergency certificate, we need you to address the interests of justice test. And that requires that the services you wish to provide need to be provided before there will be time for the agency to make a determination on a substantive application, and that the seriousness of the consequences of those services not being provided would have a substantial impact on your client's case. So in non-family work, it would be possibly missing a judicial review time limit, or not being able to file a defence to possession proceedings. And lastly, on this section, if you are submitting a non-delegated functions emergency in circumstances where you do actually have the power to delegate, please explain why delegated functions have not been used. In most cases, we will expect you to use delegated functions if you have them, but it may be a case where you're not entirely sure about the merits of the case and you want us to make the decision, or you may have concerns about whether or not the client qualifies financially for legal aid, and or that they have complex means and you want us to look at those first. If either of those situations arise, please explain again in the merits report why delegated functions have not been used and why you are wanting us to make the decision on the emergency application. That brings to an end this section on the initial requirements on legal aid applications. So I'll hand you over to my colleague Stephen Spittlehouse to take you through the next part of the session, which will be covering housing disrepair, counterclaims in possession proceedings and unlawful eviction matters.
Thank you, Peter. Hi, my name is Stephen Spittlehouse, and like Peter, I'm a technical lead for merits. This session is to go over a few of our common proceedings. It'll be disrepair, counterclaims and unlawful eviction, as Peter says, and information we require so we can get it right first time. The first part will be disrepair cases or risk to health and safety of a rented home. Disrepair proceedings brought into scope by virtue of paragraph 35, schedule 1, part 1 LASPO. However, legal aid is only available if the risk arises from a deficiency in the individual's home, which has been rented or leased from another person, and if the disrepair poses a serious risk of harm to the health or safety of the individual or relevant family member. It only extends to those services necessary to remove or reduce that risk, and if a certificate is issued, it will be limited appropriately in order to remove or reduce the identified risk. The legal aid certificate does not cover any claims for damages arising from disrepair. Any claim, if you bring a claim for damages for disrepair, those will be considered out of scope. Prior to receiving any application, we'd expect the pre-action protocol to have been followed first, which can be done under legal help, unless it's impractical to do so. So, for example, if the disrepair is such a significant risk that an urgent injunction is required to compel a landlord to carry out those repairs. Further information in relation to disrepair can be found in Lord Chancellor's guidance at section 12. For every application, we would need a detailed statement of case, setting out the position and the disrepair the property suffers from, identifying how it is a risk. Copies of the pre-action correspondence with the landlord in an attempt to avoid litigation, unless, of course, it was impractical to do so. Copy of the surveyor's report setting out disrepair, which can be obtained under legal help, and or even medical evidence which supports the risk to the health if a copy of that is available. Next section, we'll be dealing with counterclaims of possession proceedings. Possession proceedings are brought into scope by virtue of paragraph 33. Counterclaims are brought into scope by paragraph 33(6)(a), which refers to services provided to an individual in relation to a counterclaim in proceedings for a court order for sale or possession of the individual's home. However, a counterclaim is only in scope if it is in relation to the possession order being sought and assists with the defence to the possession claim. There is an exception, which we will go over later. So, for example, in an arrears claim, a counterclaim for disrepair would be in scope because any damages received could be used to offset the arrears of rent, which would provide a defence. However, same counterclaim for disrepair would not provide a defence to possession brought on the basis of antisocial behaviour. So a counterclaim would be out of scope as it would not assist with the defence. Similarly, where proceedings have been issued under the accelerated procedure following the service of section 21 notice, any counterclaim for damages for failing to protect the deposit would also be out of scope. For every application, we need a copy of the claim form, a copy of the particulars of claim and supporting documentation, including any court orders. As been mentioned previously, a detailed statement of case, which set out your client's defence and counterclaim, or if you've already filed a defence and counterclaim to court, a copy of that. We need that so we can determine whether the requirements of merits regulations 61 are satisfied, and in particular whether your client has a defence to the claim. Continuing with possession and counterclaims, I mentioned previously that was an exception to the rule that the counterclaim has to assist with the defence, and the exception is an Equality Act claim. A claim under the Equality Act is in scope under paragraph 43. It can be run either as a standalone claim or can be brought as a counterclaim if raised as part of possession proceedings and the actions of the landlord were a breach of the Equality Act. The claim must still satisfy the relevant merits criteria, which is in relation to determinations for full representation. So the prospects and cost benefit needs to be addressed. The statement must set out the breaches of the Act and how the client is being discriminated against, which gives rise to the claim. The last part of this section is unlawful eviction claims. Claims for unlawful eviction are in scope under paragraph 33(1)(b), and it relates to the eviction from the individual's home of the individual or others. We'd need to know if the application's for re-entry or if it's for damages only. And if it is damages only, we'd require a reasonable assessment of the amount of damages your client is likely to recover and how you've quantified those damages. To show of the case that satisfies the proportionality test, we'd also need the expected costs to trial. If it is a damages claim and you've assessed prospects of success as at least good, which is 60% plus, the application must address why it's considered unsuitable for CFA, including the questions whether AT insurance is available, and we'd really expect you to evidence that attempts have been made to obtain CFA before applying for legal aid. Further information in relation to CFAs can be found in the Lord Chancellor's guidance at paragraph 716 and 721. For every application, we need a detailed statement of case. It sets out the circumstances of the eviction and what remedy is sought, and if damages, as mentioned previously, the breakdown of those damages with the cost to recover them. We'd require a copy of all correspondence of the landlord, if applicable, made in an attempt to regain entry or secure damages. That concludes this section, and I will pass you back to Peter.
Okay, thanks, Stephen. I'm going to conclude the session now with a brief run through on homelessness appeals and judicial reviews and the information we require in support of those applications. Homelessness appeals are brought into scope by paragraph 34 of Schedule 1, Part 1 LASPO, and the statement in support of the application should identify the flaws in the local authority decision and the point or points of law on which the appeal is going to be based. Now, as a minimum, we would need to see the Section 202 decision under challenge, together with a statement setting out the basis of that challenge and the proposed grounds for the appeal. Additional information that would assist us in our decision making would include the original Section 184 decision, so that we can compare that with the subsequent Section 202 decision to see where, if at all, the local authority's position has altered. We would like to see copies of any representations that were made in support of the Section 202 request, so that we can see on what basis the original 184 decision was challenged. Copy of any minded to letter where the local authority is considering upholding the adverse decision, but is giving the opportunity for further representations. And whilst we accept not all firms do this, we are aware that some firms do instruct counsel at an early stage. So if counsel's opinion has already been obtained, a copy of that opinion should be uploaded with the application. It's not compulsory, and we certainly shouldn't be insisting on asking for a copy of counsel's opinion, because that is the purpose for which you're applying for legal aid. But as I say, we know that some firms do, as a matter of course, instruct counsel before applying for a certificate and have already obtained an opinion. Moving on to judicial review cases. These are all brought into scope under paragraph 19 of Schedule 1, Part 1 LASPO. And we need to know that you have exhausted all alternative remedies prior to moving to judicial review. So if there was any sort of internal review process or complaint scheme or ombudsman scheme which would provide a suitable alternative route to settlement for the client, we would expect that to have been pursued, or an explanation as to why it wasn't appropriate. We need to see details of the act or omission under challenge, so a copy of the decision from the local authority or an explanation as to the lack of a decision where they are being requested to do something but have failed to carry out that request. Regulations 54 and 56 of the merits criteria regulations require that at the very least the challenge has been notified to the respondent, and in cases for full representation that you have sent a protocol compliant letter before action, except in situations where it is so urgent that it's impractical to do so. So please ensure a copy of that pre-action correspondence is uploaded with the application. We also need to see that a copy of any response to the letter before action, assuming one has been received. If a response hasn't been received, please confirm that that is the case. And please also ensure that the statement of case addresses the flaws in the initial decision or in any response to the letter before action, and sets out on what basis it is considered that the decision is illegal, irrational, or procedurally improper, or is otherwise susceptible to challenge, say under European Convention grounds. If we are provided with all of that information at the outset, it does make our lives a lot easier in terms of making a decision, and it does enable us to get that decision correct at the first time of asking, and it means there isn't any to and fro between us asking for more information. There may be times that the information you've provided does contain gaps or prompts us to ask for something in addition to that which has already been provided. Sometimes those cases are unavoidable, but in the vast majority of cases, if we have all of that information, we will be able to make a decision at the first time. And that brings to an end this session.